Hi, my name is Courtney Brennan, and I'm an associate in the Burns-White Litigation Practice Group, where I focus in the areas of employment, business, and complex and commercial litigation. I hope you enjoyed this segment from a recent webinar, and I hope that you find it helpful. Over the last year, employers have obviously been faced with making very difficult decisions regarding employees and trying to continue business remotely. And with that came fluctuations in some employees being temporarily furloughed, laid off, and employees being brought back. So we're beginning to see claims arising under the Families First Coronavirus Act, or the FFCRA. And as you'll recall, that act allowed employees to take sick leave or expanded family and medical leave for specific qualifying reasons surrounding COVID-19. One of those cases was recently filed right here in the Western District of Pennsylvania, involving a Pittsburgh area consulting firm and a former employee who alleged that he was following his doctor's recommendation to self-quarantine after a family member was exposed to COVID-19. Now, the doctor's instruction was for the employee to quarantine, even though he himself had tested negative for the exposure. But the lawsuit goes into detail that, while the employee attempted to comply with his doctor's orders, his supervisor ordered him to report to work. So when he didn't show up for work, his employment was terminated. Now, while there's still a lot of ambiguity regarding the FFCRA and how these types of claims will play out, it certainly serves as a reminder for employers to continue not only taking the necessary precautions, but also not to hastily ignore or downplay an employee who is acting upon doctor's instructions. So we're also seeing a trend of cases involving retaliation and constructive discharge. In the Middle District of Pennsylvania, a manager has filed a claim under the FFCRA, specifically alleging that she requested to adjust her work schedule based on her son's school closures because of COVID-19, and further alleges that her employer not only was unable to meet this request, but was allegedly told that if she took FFCRA leave, she would be demoted when she returned. Not only does this serve as another reminder for employers in how to handle these types of requests, but it emphasizes the importance of communicating with your managers and your supervisors, because these are often the individuals who are interfacing more frequently with employees and who are hearing these types of requests. So that plaintiff specifically alleged that while they were unable to meet her request, she was forced to resign. So this is how we're seeing sort of the constructive discharge claims coming in with COVID-19. But through these cases, it's important to remember that even though the FFCRA expired on December 30th of 2020, the Act provides for a private cause of action. So that means the statute of limitations for claims under the FFCRA is 2 years from the date of the alleged violation, or 3 years even for an allegation of willful violation of the Act. So even if you are not continuing to provide the FFCRA leave into 2021, it's important for employers to not let their guards down. Now, like I said, there's a voluntary option for employers to extend providing the FFCRA leave to employees through September 30th of 2021 under the American Rescue Plan, which is, important for employers to follow the obligations under the law related to employee eligibility entitled to FFCRA leave, or risk possible litigation if you choose to continue providing that leave. The American Rescue Plan adds on additional non-discrimination rules regarding denying tax credits to employers that discriminate against certain categories of employees when determining availability of paid leave. That means employers that decided to continue providing FFCRA leave should make sure they're continuing to do so uniformly to reduce the risk of potential claims.